And how does a visa applicant become notified of this criterion?
There's a notice of an intention to consider refusal of the visa application on that basis. So there would be natural justice provided by way of a letter that is sent to the applicant, and the department will set out in that letter why they consider the information to be either false or misleading, or the document to be bogus.
Right. And generally, how is that letter set out? Is it quite a general accusation?
Sometimes there's not a great deal of information, and the lawyer can seek further information and really try and push the department. Sometimes there have been matters where there's been a prosecution of a third party who has been providing false work references, for example, and there's been a suppression order made in the courts. So it's quite difficult then to meet that allegation because the information has been suppressed.
So where there hasn't been much information given in that notice letter, can you ask the department for more information, and do they have to give it?
Absolutely. The client should be placed in a position where they can provide evidence to counter the allegation that either the information was not in fact false or misleading, or the document was not bogus, and also provide evidence potentially as to the waiver, because there is a waiver that may apply in the particular circumstances if the department does not accept the evidence that in fact the material was not bogus or misleading.
And can I interrupt if you could let us know more about what should people do to get a waiver?
So the provision sounds very strict. The interests of Australia, so that could be trade or business links, might be affected. That would be one basis for a waiver. Or the interests of an Australian citizen or permanent resident would be affected if the 3-year ban was imposed. So in relation to the impact on an Australian citizen or permanent resident, that must be an impact that exists over and above what would exist anyway in relation to the visa category being applied for. So if it's a partner visa application and there's a bogus document included in it, then you cannot simply rely on your Australian partner missing you for the next 3 years. You need to find a basis in policy that extends beyond what would ordinarily be part and parcel of that particular visa category. So it's a very high bar. Mm-hmm. We are finding that the tribunals are more generous, so I would certainly recommend to applicants that they do appeal any decision to the Migration Review Tribunal, because the discretion is there, and we're finding that in the tribunals all sorts of evidence about a person's integration in Australia, the assistance that they provide to neighbours and friends, their work history, all their relationships essentially in Australia, and whether they have benefited Australia in a broader sense are taken into account.
And what about the response to the department's letter? How does one go about doing that?
As Karyn mentioned, one of the issues that we face is some of the letters that we see, Karyn, these days are not sufficiently particularized. It's almost general. So an applicant or a client cannot respond to the department in a meaningful manner because it's not about her. Sometimes it's his or her, the accusation that's directed at that person, but as a general towards a class of people. So you have to ask questions from the department. If there are any evidences, obtain the evidences, and also you could or you should request the full departmental file under the Freedom of Information laws and know exactly what the accusation is, and then respond in a proper manner. So
can someone respond on their own, or should they be seeking the help of someone else?
It depends on the circumstances and the knowledge of the person. I would suggest to get a professional legal advice in relation to these matters. I don't think that you should just write a letter saying that I'm innocent. It should address it should be strategic as well.
Okay. And Karyn, you've mentioned the 3-year ban. Is that the only consequence if the department, after your response, still finds that you've provided a bogus document?
No, there are a number of other powers that the department has, and that's why my opinion is that it's an overreaction by the department. The department can cancel any current visas on character grounds. They can prosecute or seek that the Office of Public Prosecutions prosecute an applicant for the provision of false or misleading information or a bogus document. There are a number of provisions in the Criminal Code as well as in the Migration Act, and we're seeing, particularly under this government, a great increase in the number of prosecutions of people, and those do carry some quite serious penalties, criminal penalties.
Right. Now, going to the visa cancellation or refusal of the application, what can you do if you don't agree with the department's decision?
You can appeal to the Migration Review Tribunal. There are members there who are legally trained, the majority are legally trained, and they apply the latest case law. There is quite a lot of flexibility around the level of proof required, quite a number of cases coming through that are really very significant in terms of how you would prepare a case and how you might meet those allegations. Also, as I mentioned earlier, the waiver is, in my opinion, more likely to be exercised by a tribunal member than by a delegate of the department.
Right.
And Karyn, what do you think about the power to cancel? You mentioned that the government nowadays have power, lots of power, and also the power to cancel even though application has already been granted a visa. What do you think about it?
Well, there is a power under Section 501, which is very broad. It applies not only to past criminal actions, but also breaches of the Migration Act and an applicant's general character. So that could encompass anything. I think the reason this was introduced was perhaps because it was felt that a permanent ban, which is the impact of a Section 501 cancellation or refusal on character grounds, was perhaps too strict. And this was a middle ground. It was a 3-year ban, not a permanent ban. But the problem is, as ever, in its implementation, and it seems to have taken on a life of its own now.
So, Dinesh, Karyn touched on the Migration Review Tribunal. What is their role generally? Do they have to be, do they come in as an independent? Do they have to assess independently and objectively?
Yes, the Migration Review Tribunal is different from the Department of Immigration, but they can stand in the shoes of the original decision maker, but make decisions and take into consideration things until the time of the decision. It's more informal than a court of law, and the evidentiary requirements as well. The client can put his or her story, evidences, submissions, statutory declarations, bring in witnesses, and so on. And the tribunal itself must follow certain guidelines as well, and the hearing must be a proper hearing. Natural justice provisions must be adhered to, and the fairness needs to be given to the applicant or the client.
Does the Migration Review Tribunal besides during the hearing, give the applicant an invitation to respond? Is there any other time that they can comment besides during the hearing?
There is the provision to provide natural justice through either a letter or orally at a hearing. So if there is any adverse information that's particular to an applicant, the tribunal is obliged to tell an applicant. It's difficult to deal with it if it's done orally at a hearing because you don't have much notice. Generally it's done in writing ahead of a hearing so that an applicant can fully prepare.